The Philippine Phosphate Fertilizer Corporation, or Philphos, operates on a massive industrial scale, manufacturing and exporting fertilizer products from a sprawling corporate footprint. In 2006, that massive footprint became a liability. The company suffered a catastrophic financial hemorrhage, recording an audited net loss of nearly 1.96 billion pesos in a single year. Management responded by initiating a corporate downsizing program. They terminated 87 rank-and-file workers, paid out the standard separation pay, and secured signed quitclaims from the departing staff. When a group of these workers sued for a legal dismissal, the lower labor tribunals initially validated the company's actions. Both the labor arbiter and the NLRC ruled that the mass termination was a textbook exercise of management prerogative, properly executed to prevent further financial ruin. But the Supreme Court reversed those rulings. After reviewing the corporate financials, the highest court declared the entire retrenchment program illegal. Under Philippine labor law, a billion peso deficit does not automatically grant an employer the license to terminate its workers. The company must first pass a strict, multi-pronged legal stress test. The legal test for retrenchment acts as a 5-stage logic gate. Philphos cleared 2 gates, providing written notice and paying separation packages, but they collapsed at the first gate, proving retrenchment is reasonably necessary to prevent substantial, sustained business losses. The Supreme Court requires an employer to prove a continuous downward financial spiral over a period of time. An isolated drop in revenue for a single year is legally insufficient to justify mass terminations. Philphos relied entirely on its 2006 audited financial statement to prove its dire situation, but examining the timeline reveals a critical chronological defect. The company executed its retrenchment program on January 18, 2007. The independent auditor's report they used to justify those firings was not actually issued until over 3 months later. A corporation cannot claim they acted in good faith based on a financial audit that did not exist when the workers lost their jobs. That brings us to the core mathematical reasoning of the court, the last resort proportionality test for operational savings. Management presented a primary operational defense. Firing the 87 workers successfully saved the company over 38 million pesos in salaries and benefits. This chart compares the massive 1.9 billion peso loss against the 38 million recovered by terminating staff. The retrenched employees' salaries constituted less than 2% of the deficit. Cutting 2% fails to effectively prevent expected losses. Furthermore, the employer bears the absolute burden of proving they exhausted other, less drastic cost-cutting measures before touching the rank-and-file workforce. Prior measures include reducing executive bonuses, cutting management perks, or improving manufacturing efficiencies. Philphos presented zero evidence of attempting any of these strategies. When labor savings amount to a statistically insignificant drop in a massive corporate deficit, the retrenchment ceases to be a necessary survival tactic. It becomes an arbitrary penalty on the workers' livelihoods. This leads to the final requirement of the stress test, using fair criteria to ascertain exactly who is retrenched and who is retained. The execution of this downsizing specifically targeted senior employees, many of whom had served the company for 23 years. Specific veteran workers were selected for termination over newer staff. The absence of transparent selection criteria automatically violates the legal requirement of good faith, rendering the dismissals arbitrary by default. Without objective, documented criteria to guide the process, a corporate retrenchment program is legally indistinguishable from a targeted purge. With the retrenchment ruled illegal, Philphos leaned on a fallback defense. 27 of the retrenched employees had already voluntarily signed receipt and release documents. It is a common corporate misconception that paying separation pay and securing a signed quitclaim permanently shields a company from future litigation. The Supreme Court views quitclaims as dependent contracts. Because the underlying retrenchment was proven illegal, the associated quitclaims became inherently void. This relies on vitiated consent. An employee's signature is legally compromised by the economic duress caused by a sudden, unjustified job loss. Accepting a separation check does not stop an illegally fired employee from suing their former employer. The amounts they already received are simply deducted from their final legal award. A quitclaim is only as legally durable as the dismissal it covers. Paperwork cannot sanitize an illegal act.
In the final remedy phase, the court focused on two specific employees, Mayal and Beltran, who actively demanded their jobs back. The Court of Appeals initially denied their reinstatement. They cited the strained relations doctrine, the premise that the lawsuit itself made the employer-employee relationship too toxic to continue. The Supreme Court issued a sharp correction. Litigation naturally breeds hostility, but that inherent friction alone is not enough to permanently strip a worker of their tenure security. The rule is strict. Strained relations must be proven as a demonstrable fact. It cannot be loosely applied based solely on the existence of a legal dispute. The court assigned massive final liability to Philphos. They ordered full reinstatement for the employees who sought it, years of full back wages for all illegally dismissed workers, and a mandatory 10% attorney's fee penalty. The ultimate legal reality for corporate counsel is this: Article 298 is a heavily guarded exception. The management prerogative to stop financial bleeding must be chronologically documented, mathematically proportionate, and executed only as an absolute, demonstrable last resort.